All right, welcome back to the Daily Facts. This is part three of the review of the um, Inspector General Horowitz's report on Crossfire Hurricane. So let's get right into it, right where we left off. Again, this is part three. FBI's efforts to evaluate the Steele reporting. Steele's handling agent told us that when Steele provided him with the first election reports in July 2016 and described his engagement with Fusion GPS, it was obvious to him that the request for the research was politically motivated. The supervisory intelligence analyst who supervised the analytical effort for the Crossfire Hurricane team, supervisory intel analyst, explained that he also was aware of the potential for political influences on the Steele reporting. The fact that the FBI believed Steele had been retained to conduct political opposition research did not require the FBI, under either DOJ or FBI policy, to ignore his reporting. The FBI regularly receives information from individuals with potentially significant biases and motivations, including drug traffickers, convicted felons, and even terrorists. The FBI is not required to set aside such information. Rather, FBI policy requires that it critically assess the information. We found that after receiving Steele's reporting, the Crossfire Hurricane team began those efforts in earnest. We determined that the FBI's decision to receive Steele's information for Crossfire Hurricane was based on multiple factors, including one, Steele's prior work as an intelligence professional for, and that part is redacted, two, his expertise on Russia, three, his record as an FBI CHS, four, the assessment of Steele's handling agent that Steele was reliable and had provided helpful information to the FBI in the past, and five, the themes of Steele's reporting were consistent with the FBI's knowledge at the time of Russian efforts to interfere in the 2016 US elections. However, as we described later, as the FBI obtained additional information raising significant questions about the reliability of the Steele election reporting, the FBI failed to reassess the Steele reporting relied upon in the FISA applications and did not fully advise NSD or OI officials. We also found that the FBI did not aggressively seek to obtain certain potentially important information from Steele. For example, the FBI did not press Steele for information about the actual funding source for his election reporting work. Agents also did not question Steele about his role in a September 23, 2016 Yahoo News article entitled U.S. Intel Officials Probe Ties Between Trump Advisor and Kremlin, that described efforts by U.S. intelligence to determine whether Carter Page had opened communications channels with Kremlin officials. As we discuss in chapters 5 and 8, the FBI assessed in the Carter Page FISA applications without any support that Steele had not directly provided the information to Yahoo News. The first application for FISA authority on Carter Page. At the request of the FBI, the department filed 4 applications with the FISC seeking FISA authority targeting Carter Page. The first application on October 21st, 2016, and 3 renewal applications on January 12th, April 7th, and June 29, 2017. A different FISC judge considered each application and issued the requested orders, collectively resulting in approximately 11 months of FISA coverage targeting Carter Page from October 21st, 2016 to September 22nd, 2017. We discussed the first FISA application in this section and in Chapter 5. Decision to seek FISA authority. We determined that the Crossfire Hurricane team's receipt of Steele's election reporting on September 19th, 2016, played a central and essential role in the FBI's and department's decision to seek the FISA order. As noted above, when the team first sought to pursue a FISA order for Page in August 2016, a decision was made by OIG, OI, or both that more information was needed to support a probable cause finding that Page was an agent of a foreign power. As a result, FBI OGC ceased discussions with OI about a Page FISA order at that time. On September 19th, 2016, the same day that the Crossfire Hurricane team first received Steele's election reporting, the team contacted FBI OGC again about seeking a FISA order for Page and specifically focused on Steele's reporting in drafting the FISA request. 2 days later, on September 21st, the FBI OGC unit chief contacted the NSD OI unit chief to advise him that the FBI believed it was ready to submit a formal FISA request to OI relating to Page. Almost immediately thereafter, OI assigned an OI attorney, to begin preparation of the application. Although the team was interested in seeking FISA surveillance targeting Papadopoulos, the FBI OGC attorneys were not supportive. FBI and NSD officials told us that the Crossfire Hurricane team ultimately did not seek FISA surveillance of Papadopoulos, and we are aware of no information indicating that the team requesting or seriously considered FISA surveillance of Manafort or Flynn. We did not find documentary or testimonial evidence that political bias or improper motivation influenced the FBI's decision to seek FISA authority on Carter Page. Preparation and review process. As we detail in Chapter 2, the FISC rules of procedure and FBI policy required that the Carter Page FISA applications contain all material facts. Although the FISC rules do not define or otherwise explain what constitutes a material fact, FBI policy guidance states that a fact is material if it is relevant to the court's probable cause determination. Additionally, FBI policy mandates that the case agent ensure that all factual statements in a FISA application are scrupulously accurate. On or about September 23rd, the OI attorney began work on the FISA application. Over the next several weeks, the OI attorney prepared and edited a draft application using information principally provided by the FBI case agent assigned to the Carter Page investigation at the time, and in a few instances by an OGC attorney or other Crossfire Hurricane team members. The drafting process culminated in an application that asserted that the Russian government was attempting to undermine and influence the upcoming U.S. presidential election, and that the FBI believed Carter Page was acting in conjunction with the Russians in those efforts. The application statement of facts supporting probable cause to believe that Page was an agent of Russia was broken down into 5 elements. The efforts of Russian intelligence services, RIS, to influence the upcoming U.S. presidential election. The Russian government's attempted coordination with members of the Trump campaign based on the FFG information reporting the suggestion of assistance from the Russians to someone associated with the Trump campaign. Page's historical connections to Russia and RIS. Page's alleged coordination with the Russian government on 2016 U.S. presidential election activities based on Russia's reporting, and Page's statements to an FBI CHS in October 2016 that he had an open checkbook from certain Russians to fund a think tank project. In addition, the statement of facts described Page's denials of coordination with the Russian government as reported in two news articles and asserted by Page in a September 25th letter to then FBI Director Comey. The application received the necessary department approvals and certifications as required by law. As we fully described in Chapter 5, this application received more attention and scrutiny than a typical FISA application in terms of the additional layers of review and number of high-level officials who read the application before it was signed. These officials included NSD's Acting Assistant Attorney General, NSD's Deputy Assistant Attorney General with oversight over OI's Operations Section Chief, and Deputy Section Chief, the DAG, Principal Associate Deputy Attorney General, and the Associate Deputy Attorney General responsible for ODAG's national security portfolio. However, as we explain below, the department decision makers who supported and approved the application were not given all relevant information. Role of Steele election reporting in the first application. In support of the fourth element in the FISA application, Carter Page's alleged coordination with the Russian government on 2016 U.S. presidential election activities, the application relied entirely on the following information from Steele reports 80, 94, 95, and 102. Compromising information about Hillary Clinton had been compiled for many years, was controlled by the Kremlin, and had been fed by the Kremlin to the Trump campaign for an extended period of time. Report 80. During a July 2016 trip to Moscow, Page met secretly with Igor Sechin, chairman of Russian energy conglomerate Rosneft and close associate of Putin, to discuss future cooperation and the lifting of Ukraine-related sanctions against Russia, and with Igor Devyakhin, a highly placed Russian official, to discuss sharing with the Trump campaign derogatory information about Clinton. Report 94. Page was an intermediary between Russia and the Trump campaign's then manager, Manafort, in a well-developed conspiracy of cooperation which led to Russia's disclosure of hacked DNC emails to WikiLeaks in exchange for the Trump campaign's agreement to sideline Russian intervention in Ukraine as a campaign issue, Report 95, and Russia released the DNC emails to WikiLeaks in an attempt to swing voters to Trump, an objective conceived and promoted by Page and others. Report 102. We determined that the FBI's decision to rely upon Steele's election reporting to help establish probable cause that Page was an agent of Russia was a judgment reached initially by the case agents on the Crossfire Hurricane team. We further determined that FBI officials at every level concurred with the judgment, from the OGC attorneys assigned to the investigation to senior CD officials, then General Counsel James Baker, then Deputy Director Andrew McCabe, and then Director James Comey. FBI leadership supported relying on Steele's reporting to seek a FISA order on Page after being advised of and giving consideration to concerns expressed by Stuart Evans, then NSD's Deputy Assistant Attorney General with oversight responsibility over OI, that Steele may have been hired by someone associated with presidential candidate Clinton or the DNC, and that the foreign intelligence to be collected through the FISA order would probably not be worth the risk of being criticized later for collecting communications of someone, Carter Page, who was politically sensitive. According to McCabe, the FBI felt strongly that the FISA application should move forward because the team believed they had to get to the bottom of what they considered to be a potentially serious threat to national security, even if the FBI would later be criticized for taking such action. McCabe and others discussed the FBI's position with NSD and ODAG officials, and these officials accepted the FBI's decision to move forward with the application based substantially on the Steele information. We found that FBI did not have information corroborating the specific allegations against Carter Page in Steele's reporting when it relied upon his reports in the first FISA application or subsequent renewal applications. OGC and NSD attorneys told us that while the FBI's Woods procedures, described in Chapter 2, require that every factual assertion in a FISA application be verified when information is attributed to a FBI CHS, the Woods procedures require only that the agent verify with supporting documentation that the application accurately reflects what the CHS told the FBI. The procedures do not require that the agent corroborate through a second independent source that what the CHS told the FBI is true. We did not identify anything in the Woods procedures that is inconsistent with these officials' description of the procedures. However, absent corroboration for the factual assertions in the election reporting, it was particularly important for the FISA applications to articulate the FBI's knowledge of Steele's background and its assessment of his reliability. On these points, the applications advised the court that Steele was believed to be a reliable source for three reasons: his professional background, his history of work as an FBI CHS since 2013, and his prior non election reporting, which the FBI described as corroborated and used in criminal proceedings. As discussed below, the representations about Steele's prior reporting were overstated and had not been approved by Steele's handling agent as required by the Woods procedures. Due to Evans' persistent inquiries, the FISA application also included a footnote developed by OI based on information provided by the Crossfire Hurricane team to address Evans' concern about the potential political bias of Steele's research. The footnote stated that Steele was hired by an identified U.S. person, Glenn Simpson, to conduct research regarding Candidate 1's, Donald Trump, ties to Russia, and the FBI speculates that the U.S. person was likely looking for information that could be used to discredit the Trump campaign. Relevant information inaccurately stated, omitted, or undocumented in the first application. Our review found that the FBI personnel fell far short of the requirement in FBI policy that they ensure that all factual statements in a FISA application are scrupulously accurate. We identified multiple instances in which factual assertions relied upon in the first FISA application were inaccurate, incomplete, or unsupported by appropriate documentation based upon information the FBI had in its possession at the time the application was filed. We found that the problems we identified were primarily caused by the Crossfire Hurricane team failing to share all relevant information with OI, and consequently, the information was not considered by the department's decision makers who ultimately decided to support the applications. As more fully described in Chapter 5, based upon the information known to the FBI in October 2016, the first application contained the following 7 significant inaccuracies and omissions. 1. Omitted information the FBI had obtained from another U.S. government agency detailing its prior relationship with Page, including that Page had been a approved as an operational contact for the other agency from 2008 to 2013, and that Page had provided information to the other agency concerning his prior contacts with certain Russian intelligence officers, one of which overlapped with facts asserted in the FISA application. 2. Included a source characterization statement asserting that Still's prior reporting had been corroborated and used in criminal proceedings, which overstated the significance of the Still's past reporting and was not approved by Still's handling agent as required by the Woods procedures. Oh, we're going to end there and we will pick up on part 4 here next time. Thank you so much for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment. We'll talk again soon. Bye.